Senator Deacon, Nova Scotia.
Thank you, Speaker. Honourable colleagues, I rise today to speak as sponsor of a private member's bill, C-244, entitled An Act to Amend the Copyright Act, Diagnosis, Maintenance and Repair. It comes to us having received unanimous support from the House of Commons, which is kind of rare these days. The legislation plays an important role in enabling the implementation of right-to-repair frameworks across the federal, provincial, territorial levels of government in Canada. Giving Canadians the right to repair their products strengthens their consumer rights. It reduces their costs, it helps to increase competition, and it reduces harms to the environment. Specifically, Bill C-244 amends the Copyright Act to allow a person to circumvent a technological protection measure, or a TPM. I didn't know about these either before now, folks, so hang on there with me. But only when the purpose is solely to diagnose, maintain, or repair a product. A TPM is also known as a digital lock because it prevents, for example, a repair technician from accessing software code, consequently preventing them from repairing a product. My hope is that by the end of my speech, you'll appreciate why this private member's bill was unanimously supported in the House of Commons. But before I get into the substance of the bill and its regulatory implications, I'd like to step back and speak about right to repair more generally and how it promises to help Canadians and small businesses in every corner of the country. I'll then speak about the bill itself and why it's central to making progress on right to repair. And lastly, I'll wrap up my comments by positioning the bill relative to another piece of legislation on our order paper, Bill C-294. So what is right to repair and why does it matter? Let me start with a personal example. In 2019, we bought a new dishwasher. We gambled and lost because we bought the cheapest version of a supposedly respected brand, but we did not buy the extended warranty. It broke 2 years later. I happened to live in an area with a well-respected repairman who said, at no cost, he politely listened to what I thought the problem was. And when he finished, he asked a couple more questions. He said, well, it's the pump. It's the thing that goes first on that model. And if you prefer, I could come over and diagnose it in person and charge $150 plus HST for the same answer that I'm giving you now. He went on to say, if you choose to fix it, with parts and service and HST, it's probably going to cost you about $600. For the same price, he said, you can buy a brand new dishwasher, but this time get the extended warranty. And he said, when it breaks, call me. He'll fix it for no charge. I'm not happy with the fact that the appliances at all price points are so poorly made that the manufacturer manufacturers overpriced components are taking about half of his total sales. He's not happy about that. But at least he's found a way to make sure that the community he serves knows that he's not the one who's ripping them off. Most importantly, it's outrageous that he is so confidently predicting that the new appliance will almost certainly fail within 5 years. Yes, we took his advice. We bought a new dishwasher, and yes, we got the extended warranty, and then carried the one with the broken pump out to the end of the road, destined for the landfill. Needless to say, I wasn't happy. This concept, where products are intentionally designed to have a limited lifespan, is known as planned obsolescence. Consumer rights groups have and do push back in the most egregious of cases, but they need the help of legislators. In many jurisdictions, this help is well underway, and the balance of power is finally shifting away from global manufacturers and back to consumers. When our dishwasher failed, I couldn't help to think back to my parents' purchase of a matching set of appliances. It was 1972, so most of you can probably guess the color of those appliances. Yep, avocado green, the pinnacle of fashion. Despite their color, these appliances were used continuously by 4 different households, requiring only minimal repairs until they were finally retired in 2007. They delivered 35 years of reliable service, but it still wasn't long enough for avocado green to come back into fashion. Today, poor quality and planned obsolescence has become the expected norm. From a selfish business perspective, it makes sense. Why would a manufacturer make one sale every 35 years when they can make a sale every 5 or less? Why would they empower others to maintain and repair their product without ensuring that they can maximize their share of repair costs through licensing fees, specialized tools, and expensive components. If you listen to podcasts, I recommend that you listen to CBC's What on Earth with Lauren Lynch, specifically the episode from November 1st last year called Let's Talk About All Your Broken Stuff. In this episode, she cites countless examples of products that are seemingly designed to become quickly obsolete. When you consider all of the energy, effort, and environmental costs involved with extracting and refining raw materials, designing and manufacturing a product, and then transporting it around the globe, it's entirely unsustainable and unacceptable for our homes to simply be a pit stop for that product as it travels from the other side of the globe into a local landfill. Money and carbon are being burned for a steadily diminishing return because designed obsolescence is so easily invisibly achieved. For example, when the magnet required to ensure a tight seal on an expensive refrigerator door is not designed to be replaced, an otherwise excellent refrigerator is sent to the landfill. Or when a specialized battery is glued into a device, making it impossible to swap out and replace with a standard battery, it too ends up in the landfill. Suddenly, regardless of the price point, too many of our consumer products are becoming garbage. I was thrilled when I heard CBC's What on Earth actually reference Bill C-244 as an example of important progress on the path to extending the reliability and lifespan of consumer products. The show's host referenced the fact that virtually every product today is a smart product because it is controlled by some form of computer chip. This chip contains software under our current copyright law. Manufacturers use TPMs or digital locks to prevent third parties from accessing their software code, even when the reason is to diagnose and repair the product. Allow me to provide another personal example. I'm full of them on this. Last winter, the check engine light came on in our car. I called our local garage in rural Nova Scotia. The mechanic said he couldn't count on being able to fully access the car's computer, so he told me that I should go down to the dealership. I phoned and made an appointment, drove an hour into Halifax. When I arrived, I waited an hour and was asked to pay $100. Why? Because the gas cap was not entirely sealed, which set off the sensor in the gas tank, triggering a check engine light, and needless to say, my hour-long drive home was powered by frustration. I had just wasted over 3 hours and $100 because the vehicle manufacturer doesn't allow others to fully access the car's software for the purposes of maintenance, diagnosis, and repair. Or in this case, a simple insight that their gas cap needs to be tightened another half turn. Automotive industry manufacturers point to an existing agreement with the aftermarket repair industry called the Canadian Automotive Service Information Standard, or CASIS. This voluntary agreement allows, in principle, for, quote, auto manufacturers to share service and repair information with the automotive aftermarket industry on a level equivalent to information available to authorized dealerships. This sounds like it achieves right to repair without having to amend the Copyright Act. However, the CASIS agreement hasn't been updated since 2009, has no enforcement mechanism, and compliance is not mandatory. A car uses software for just about anything and everything today, unlike in 2009, meaning that a TPM can legally block something as simple as a taillight repair. This agreement is no longer fit for purpose. Colleagues, for much of the last century, music was distributed as a physical or tangible product, as a record, a tape, or a CD. However, as digital distribution became increasingly common, the Copyright Act was amended to provide protection rights for creators, particularly songwriters and musicians. This could be seen as a natural extension of existing copyright laws for tangible assets like books and pieces of art. However, these TPMs have become invasive and are a manifestation of scope creep. They now effectively block consumers from having access to or control over the digital trail that they create when using products, and it prevents third-party technicians from providing maintenance and repair services to the rightful product owner. Clearly, some manufacturers, with the help of their clever lawyers, those dastardly clever lawyers, they have sought to discourage the right to repair, with all too many prioritizing short-term commercial interests. Whatever the reason, increasingly the Copyright Act is being used to block the role of independent repair service providers by threatening those service providers with copyright infringement penalties or threatening the consumer with voiding their warranty. This has the effect of reducing competition in the market to the detriment of consumers. Allow me to recap. So far, we reviewed the right to repair generally and how the unintended use of copyright laws limits competition and increases consumerism to the detriment of quality over quantity, reaping harm on our wallets and the environment. My hope is that you will now see why C-244 is a crucial starting point in the drive to secure consumer access to competitive and affordable repair services and in aftermarkets. The lack of right to repair impacts farmers, mechanics, technicians, construction workers, electronic repair shops, artisans, and all sorts of small business owners, not just consumers. Given this context, it's not surprising that C-244 was unanimously approved in the House of Commons at third reading, after 7 committee meetings where MPs heard from close to 30 industry, government, and expert witnesses. Additionally, this bill aligns with Budget 2023's announcement that the government will work to implement a right to repair, with the aim of introducing a targeted framework for home appliances and electronics this year, 2024. The government has also committed in Budget 2023 to launch consultations, including on the right to repair and the interoperability of farm equipment, and work closely with provinces and territories to advance its implementation. So Bill C-244 helps to fulfill a government priority and therefore is supported by the government, by ISED, and in addition to all the other parties in the House of Commons. The fact that Bill C-244 is industry agnostic is the primary reason why I think it's secured so much support in the House. Previous bills have attempted to use an industry-centric approach with limited success. For instance, in the past bill, C-273, introduced in 2009, sought to enable a mandated right to repair for motor vehicles only. Still, C-273 failed in the House. A similar bill, C-231, was introduced in this Parliament by the same sponsor, MP Brian Massey. His bill relates to amendments to the Competition Act, which we have just heard are now being incorporated as part of the announcements in the fall economic statement. He views his bill and the amendments to the Competition Act as complementary to C-244. So a key to why C-244 earned unanimous support in the House is that it avoided the possible litany of carve-outs, which could have defeated the general purpose intent of the bill. So now let's focus on C-244 and its implications. Bill C-244 introduces amendments to the Copyright Act, which, as you know, is an important marketplace framework law of general application designed to foster and protect cultural and economic creativity and innovation. We've discussed why amendments are needed, specifically to allow the circumvention of digital locks, which are coded into product software, but also if the circumvention is solely for the purpose of diagnosis, maintenance, and repair of a product, the product to which the software is embedded. These amendments will also allow the legal manufacturing, importation, and distribution, sale, and renting and provision of technologies, devices, and components if they are used for the diagnosis, maintenance, and repair of products. Many maintenance people have to use specific software connections and small computers to connect to products in order to service them. There's lots of individual little tools needed to be successful in maintaining products today. As an amendment to the law of general application, it is not designed to address sector-specific concerns, nor does it deal with safety, cybersecurity, or environmental matters. The changes proposed in C-244 are by design neutral and would not harm the principle or effectiveness of the Copyright Act. Importantly, this bill does not supersede existing regulations related to specific classes of products. Those regulations remain unaffected, whether they exist for safety, design, environmental, or other purposes. For this reason, it's preferable that stakeholder concerns and suggested carve-outs be addressed within the existing legislative and regulatory regimes that are specifically designed to regulate those classes of products, as is now done with medical devices and vehicles. A specific example relates to medical devices that are regulated under Health Canada. A long-standing regulatory gap exists as it relates to uncertified third-party repair shops. Bill C-244 has exposed the existence of various regulatory gaps, but specifically this one, which require the action on the part of Health Canada to address. To be clear, this bill does not impact existing regulatory safeguards, and all evidence suggests that it will force those responsible for those safeguards to increasingly strengthen them. Some stakeholders have raised concerns specifically related to software piracy. Importantly, C-244 only allows the circumvention of TPMs for the legal access of content. Piracy remains illegal. Specifically, Bill C-244 does not allow the copying or sharing of copyright-protected content if that access infringes copyright law. This measure is in Clause 2, subsection 3 of the bill. This is a concern raised by the video game manufacturers who are effectively affected by the integrity, security, and privacy risks in their marketplace. In 2017, the Canadian Federal Court awarded Nintendo $12.76 million in damages for copyright infringement under the Copyright Act, demonstrating the enforceability of the law. I want to underline that the changes proposed in C-244 do not undermine enforceability of the Copyright Act. But the concern that there is a concern that there's an increased burden of proof and therefore increased litigation costs, and that may be worth exploring during the study of the bill. In the House Committee study in Indu, there were other amendments made to Clause 2 of the bill to further strengthen the right to repair provisions and also to ensure compliance with CUSMA. I will speak on two of those consequential amendments to the original drafting of 244. First, an amendment was made to ensure that TPM circumvention for right to repair would apply to sound recording or performance if a specific sound was part of a TPM. I don't know how many of you own dishwashers or microwaves or washing machines that make certain beeps or sounds or melodies. You'll be interested to know that if that part of the part of the device that sound is connected with breaks, like a button, you'll end up having to have that serviced because it's protected by a TPM, just for the purposes of making it more difficult, I think, for affordable service to occur. This amendment empowers consumers and repair technicians to circumvent a copyrighted sound in order to fix a damaged part of the machine. I don't think any of us view that sound as being a bonus at all. And I think that's one of the things, again, that shows how the TPMs have been used against consumers. I don't know about you, but I was astonished when just to think about the legal convolution that has gone on, that a law to protect singers and songwriters was now being used in a way to protect manufacturers and increase the revenue that they secured. Talk about an anti-competitive practice. Another amendment passed at the Indu Committee ensured that C-244 complies with CUSMA and the risk that applying the repair exemption to the device circumvention prohibition could be potentially causing future trade disputes under CUSMA. This is because the CUSMA trade agreement does not permit any new exemptions for manufacturing a technology intended to circumvent a TPM. To put it more simply, while the bill will enable anyone to access service that would allow a TPM to be circumvented for the purpose of maintenance or repair, it does not allow anyone to manufacture that device specifically designed to circumvent a TPM, even for the purpose of repair. ISET officials have confirmed that this amendment would be consistent with the U.S. federal copyright framework for right to repair, therefore enabling 244 to comply with CUSMA. Lastly, I want to briefly position C-244 relative to a related bill in our order paper, Bill C-294, sponsored by Senator Houssakos. Clearly, the right to repair is about the Canadian consumer fighting back. This issue is supported by all parties, with a growing number of Canadians supporting the right to repair legislation. Indeed, it is an accompanying bill. There is an accompanying bill currently on the order paper that works in conjunction with C-244. Bill C-294, an act to amend the Copyright Act interoperability, also passed unanimously in the House and serves a complementary purpose, which I look forward to diving into as well, following our colleague's speech on this matter. There are already certain limited instances where circumventing TPMs will not infringe copyright, including circumvention for the purposes of software interoperability, encryption research, network security, and for unlocking a wireless device. C-294 will broaden that exemption to allow a person in certain instances to circumvent a TPM to make a computer program or a device in which it is embedded interoperable with another computer program, device, or component. This entirely supports the principle of a consumer's right to repair, and particularly is very important as it relates to farming equipment. Both are also crucial to the concept of a circular economy, where the whole value chain of a product is considered and is aimed toward reducing greenhouse gas emissions and other excessive waste through repairing, reusing, and recycling. These bills are part of a much broader global effort. Europe has began legislating in this area, with directives being devised in the 2010s, and member nations creating their right to repair frameworks. The UK introduced a right to repair law that went into effect in July 2021. There are currently 18 states that have implemented their own right to repair legislation. Some provinces, like Quebec, are moving ahead with legislation such as Bill 229, an act to protect consumers from planned obsolescence and to promote the durability, repairability, and maintenance of goods. And that passed last month. Bill 29 goes even further for consumer right to repair by prohibiting planned obsolescence and ensuring that merchants and manufacturers always make the parts needed to repair and service a product to be available to consumers under warranty agreements. It's the first of its kind on the continent. But before I close, colleagues, I have an admission to make. I have a very dominant Scottish gene. There are times when my family have described it as a genetic defect. I do not like to admit, right? I have to admit that I don't like to throw anything away. Leftovers are my favorite meal. Repairing rather than replacing brings me considerable joy. My noise-canceling headphones were repaired using electrical tape. The slippers I wear at home are only 20 years old, and I consider them new. I purchased some of the ties that I wear in the Senate back in the 80s. So to be clear, I prefer to be described as frugal rather than cheap, and I thank my parents, who came of age in the Depression, for that attribute. I consider it a pretty important characteristic that we need to have more of during this current cost of living crisis that is making life incredibly difficult for so many Canadians. Bill C-244 is made for the times. It will help to reduce the cost of living of Canadians by making it easier and more affordable to repair essential products. It helps to drive competition and productivity into our economy, enabling more to be done for less. It limits the plague of repairable products being sent to the landfill and all of the increased harm and waste that it's caused. But even more importantly, it makes it less profitable for companies to import lower quality products into Canada and simply sell overpriced replacement parts, or worse still, limit the ability of their products to be repaired at all. I much prefer to see higher quality products that use standardized replacement and aftermarket products, or parts I should say, maximizing the amount of money we keep in our economy and allowing Canadians, no matter where they live, to affordably repair their products, allowing for many more years of continuous and reliable use, even if those products and appliances are avocado green. Bill C-244 is an important example of the urgent need to modernize our legislation and regulations in the face of accelerating change in the digital economy. Too many of our laws and regulations intended for a specific purpose have become outdated and are now harmful and having unintended negative impacts. We need to be smarter about how we devise legislation so it is either future-proofed or offers an agile mechanism to adjust to technological change. It's important to move ahead with this bill, which is complementary to Bill C-294, so we can begin to modernize the Competition Act to align with the realities of the digital and data era. Creating a federal framework with these two bills will spearhead action from our provinces and territories and deliver benefits to consumers across Canada. And I just want to mention that a lot of this aligns with work that we did in the Banking Committee last spring and talking with the same sort of efforts. For these and other reasons, this bill was garnered unanimous support in the House. I'd like to thank my colleagues in the House, especially MP Brian May, who first introduced a version of this bill in the previous Parliament in February 2021, and the sponsor who shepherded this bill through the House in this Parliament, MP Wilson Meow. I also want to thank members of INDU in the House of Commons for prioritizing the study of this bill and investing the time necessary to improve its content. Colleagues, the Copyright Act is a law of general purpose, and this bill makes important changes that will enable the right to repair framework to be created at a federal, provincial, and territorial levels, benefiting consumers and the environment. It's universally supported and will bring meaningful change to Canadians. Thanks, colleagues.
Sénatrice Bellemare, vous avez une question?
Senator Bellemare. Inaudible. Please turn on the microphone. I'll leave you the time to put on your headset. I'll be asking my question in English. The repair and maintenance economy is something that we need to sincerely encourage in a sustainable economy. So this bill affects regulations, but it will not have any financial impact. Do you think it will have a genuine impact when it comes to the growth of repair services, electronics, for appliances, things we need, compared to more fiscal measures that exist, for example, in Scandinavia, so to discourage people from throwing things out and instead to have them repaired? Do you think this bill, then, will be able to do so?
Senatrice, thank you for your question, because it's really important. I think the main answer I would give is this is one of many things that we have to do. This is a foundation. This is a whole of the economy approach. By amending the Copyright Act, we make it now illegal to prevent independent repair shops from doing the job that is done by manufacturers. So they can't use TPMs as a way to block repair. So that's a really good start. But C-244 is another element to enable interoperability between different products and different manufacturers. There's going to be a lot of efforts needed in order for us to turn the tide on where we found ourselves in an economy that, as I say, all the manufacturing, resource extraction, everything goes on, and then something's shipped across the world, and our house is just a pit stop. It's just craziness where we're at right now. So this is one of many, many, many efforts. I'm not saying I wouldn't rule out anything else, but what I like about what this does is it makes competition more robust. And I believe in competition. I believe competition is how we get better. And those who are more expensive and have less durable products will now do worse in this environment. And to me, that's structurally really important. Where we get to on other measures, I wouldn't rule anything out. I hope that helps.
Senator Wells.
Of questions. Thank you. Thanks, Speaker. Senator Deakin, thanks very much for your speech. You've educated us quite a bit on this. You'll know that I'm the critic of this here in the Senate. Who would be against this? Who would be against this bill? Who would raise their head to be against this bill if there's such widespread support?
Senator Deakin, Nova Scotia.
Thank you, Speaker. Thank you, Senator Wells. There are lots of entrenched interests that struggle with this bill. When I speak to them about it, so far, I'm very direct, and I just said, I'm looking for observations versus amendments, if there's anything. But there's game manufacturers, for example, who say that this is going to make piracy easier. So if it's going to make it easier, it may be harder for them, as I said in my speech, to investigate and enforce the law to protect their copyrighted assets. But the reality is, if you start making one exemption, they're just going to come in a groundswell. There are others, auto manufacturers, that say we're already doing it through cases. We're already allowing access. Well, the access is not mandatory, and it's not complete, and it hasn't been updated in 15 pretty crucial years in our digital economy. So there's a number of groups that are saying, yeah, we've got real problems. I think we should always hear from the dissenting interests, but I think their issues can be managed. The other, I think I mentioned in the speech, is around medical devices. It's exposed, actually, a challenge that there are unregulated, uncertified medical device repair shops, repair personnel in the country. Well, that shouldn't exist. Then there needs to be a health regulation change. So the reality is there's a number of things that have to happen in other areas of government in order to make sure that there are no unintended consequences from this action. But as a rule, nobody is against right to repair. I think they are rightly protecting their current interests. And we can find ways to work through that.
Senator Wells.
Would you take another question, Senator Deakin? I'm thinking about the provisions for warranties. And if someone tinkers to fix something and it's under warranty, that would void the warranty. I know I had a car once. I had to bring it back to the dealership to just have oil changed every year. And if I took it somewhere else, my warranty was voided. What about that? The provisions of it affecting, private repair, affecting the warranty.
Senator Deakin.
Thank you again. Really important question. I would offer that there are other provisions. For example, if you tinker with the environmental control systems in a car, the car will not be living up to the standards that are required by law. So there are different ways in which, yes, a vehicle can be tinkered with, a piece of equipment can be tinkered with. So it'll have to change a number of different elements. Eventually, we will have to change a number of different elements. Equipment manufacturers, equipment renters will have to change the contract that they have with those that they rent equipment to make sure they don't tinker with a product. But it's the same as we would have in any other area. We have to make sure that our safety, environmental, and other laws and regulations in other areas of government are going to be enforced. What is challenging around where we're at today is that when you don't allow somebody other than just that one group, the registered dealer or whatever, to make a repair, where others can be trained to deliver it more cost efficiently and be certified and delivered safe, secure, responsible, technical repair. The lack of competition means that they can charge whatever price they want and mean that you have to do your oil change at a much higher price than you could at a competing shop that is much more convenient. Certainly in my situation, convenience is important because it's an hour to get somewhere. So I just offer each one of these things, in my mind, can be managed very carefully and very easily, but we've got to stop this prevention for the use of TPMs for purposes that are harmful to consumers.
Wells.
One final question, I promise. And would you take it? What about, you mentioned farm equipment. What about farm equipment? A lot of farm equipment is leased. So if you're leasing something to a farmer, or a grower, or a rancher, or a grain dryer, what about a provision for having that piece of equipment only serviced by someone approved by the owner of the equipment? If it was, and I shouldn't use the word tinker, I'm talking about repaired. If something goes wrong and it needs to be repaired, so you're not changing the catalytic converter or anything like that, should there not be protections for the owners of the equipment that it be done by a licensed, permitted, registered repairer, which might be them if they're the dealer for Caterpillar or John Deere or whatever?
Senator Deakin, Nova Scotia. Again,
Senator Wells, really, really important point. It will probably change how a leasing agreement is done by an equipment leasing company, where they don't allow you, and you've got to certify that you are not going to do any repairs that are not from a certified technician. That would be the case today. I mean, the reality is, when a piece of equipment goes out, there may be a TPM in place, but in other elements of the equipment, they could be making changes. And so what we have to look at on this is that, yes, there are ways in which other contracts have to change. You know, if a company can provide technical service to the equipment they're leasing at an affordable rate relative to somebody else who's saying, you know, you've got to be at this rate, the more affordable company will grow. So, but right now, what we're not allowing is competition to occur in any way, shape, or form. And so that's, for me, that's the key issue, is this opens up the opportunity for competition in various marketplaces where, I mean, speak to farmers about what they're having to deal with as it relates to the digital elements of their equipment and the lack of interoperability and the increased costs that come with that. The fact that they can't integrate in effective aftermarket components to replace a broken component, that they're just not allowed to do it. It can be done safely, but it's not allowed right now. So the market will adjust with time. Leasers will adjust with time in terms of how they deal with things, but we've got to put in place this framework solution in order to enable competition to come along and the market to adjust to that competition.
One more question, Senator. Thank you. So, first of all, during your speech, I was, I think, entirely supportive of the bill. But during some of these questions, I'm starting to get feeling a little uneasy. And I know when this bill goes to committee, many of these questions will be answered. But you've, on a few occasions now, said that, well, these things will have a way of working themselves out, and we will have to do this and that and the other in order to compensate. And I want to get back to Senator Wells's question about warranty. And I've had both manufacturers come into my office, as you have, I'm sure, lobbying against it, and farmers coming and lobbying for this. I'm also from a rural area, so you're 100 miles away from a John Deere dealer and your combine breaks. You can't stop combining, so I understand that. But my question is this, that if that combine is under warranty, are you suggesting with this bill that the farmer is allowed to try to fix something that is a warranty issue and he messes it up or she messes it up, that the dealer is still going to have to accept that and then repair something on warranty that the farmer, because he wasn't qualified to do this, tried to fix it? That I really struggle with. I support the entire competition and all of that, and I see where some of the problems are, but there I see a real problem if dealers are going to be forced to then, well, you messed it up, but we will still abide by the warranty.
Senator Deakin, Nova Scotia.
Senator Plett, thank you. I obviously was not clear. So, no, warranties will still be voided if uncertified, unqualified changes occur. I have no doubt about that. But the key is that certified technicians now could come from organizations other than just the original equipment manufacturer. And to me, that's the important element, that allows competition to emerge. But absolutely, and this is, I think, the point made by the heavy equipment leasing companies, right? And I think it's a really important point that they've made, which is, what if they lease a piece of equipment for 6 months, the person they lease it to or rent it to then makes changes, they get it back, a change has been made that has made the equipment less safe or it doesn't fulfill environmental responsibilities, then they take that on. So that's where they're going to have a very clear liability resting with the person they lease it to say, if you make these sorts of changes, you're liable for them, not the leasing company. So thank you very much. Well clarified.
Senator Richards?
Will you take a question, sir?
Certainly, thank you.
I don't know much about this, and maybe it's a question that's already been answered. But how will this square with the American manufacturer and the American monopoly on so many products? I mean, this is, 80% of our product from Massey Ferguson to toothbrushes come from south of the border. This this might pass well in Canada and go through the Senate. I'm just wondering how it will pass in Washington.
Senator Deakin, Nova Scotia.
Thank you for the question, Senator. And this does comply with CUSMA, number one. So that's a key element. So it doesn't, in fact, interrupt our trading agreement in any way. But what it does do is open the door for more competition. And that's a priority in the United States and becoming a priority in Canada, to have more competition. So the competition may come from the United States. The competition may come from Canada. But it doesn't, it loosens the lock that original equipment manufacturers have on their products and the control over the consumer's ability to maintain that product over time. And that releasing that hold on consumers and freeing up others to start to make repairs in a competitive environment, qualified competitive environment, to me only benefits consumers, and it forces greater competition amongst the manufacturers for better products that last longer and are more easily repairable. So I don't see any way, but there's going to be experts that should be questioned in committee that will look at that issue and say, where is there a potential risk at CUSMA? We've been assured by ISED, and certainly by reading the testimony in the Indu Committee in the House, that's not an issue.